Good afternoon, everyone. This is Kelly March, your 2021 president. And thank you so much for taking the time to join us today. This is going to be a very, very interesting session, and excited to have all of you, including our guests. We're recording today's session, so I want to let everybody know that you'll all receive a link to it later on as far as this week. By the way, please submit your questions via the Q&A section at the bottom of your screen, and we'll address as many of these as possible at the end of the session. So now that we've covered our housekeeping items, let's get started. You know, in July, the Department of Justice withdrew its consent to settlement agreement that was reached in 2020 with the National Association of Realtors, which resolved the issues raised by the DOJ about the commission and the Mls system. So what does this unprecedented move mean, and what's next? Well, today we're going to find out. We're honored to have Leslie Mucco, NAR's Deputy General Counsel and Vice President, Legal Affairs and Antitrust Compliance, join us today to discuss the DOJ settlement, as well as other hot topics and legal updates impacting BICs like you. So Leslie, thank you so much for joining us today. I'm going to go ahead and pass things over to you for us to get started.
Thank you, Kelly. Thank you, everyone, for being here, for joining us, and for inviting me to give you a legal update. We have a lot to talk about today, so without further ado, I'm going to get my slides up on the screen, and I will take it away. Are you seeing my slides? Hopefully. Okay. So first of all, I have to go in presentation mode. Okay. So we have a lot to talk about, as I said. I'm going to talk about the DOJ litigation that Kelly just mentioned, as well as some other litigation that is facing NAR and the industry. And then I'm going to talk about 3 hot topics that brokers like you need to know about, and how you can mitigate your risk and protect yourselves and your businesses from potential legal liability. So there we'll talk about fair housing issues, copyright and listing photos, and we'll end with ADA website accessibility. And at the end, you'll have the opportunity to ask questions about anything that I've talked about here today. So first up, the hot topic of the day is the NAR DOJ settlement. So here I want to give some brief history and background to kind of take you to where we are today. So a couple of years ago, NAR received an inquiry from the Department of Justice. The Department of Justice had questions about commissions and the Mls system. So NAR worked with the Department of Justice to try to answer their questions and resolve those questions with the Department of Justice. And what resulted from those discussions and conversations was the November 2020 settlement that was announced by President Oppler. And that settlement resolved the DOJ's questions that it brought to NAR about commissions and the Mls system. As part of that settlement that we reached with the DOJ, we agreed to make 4 key rule changes. And I have listed them here on my screen, but I'll go through each of them very briefly. So NAR agreed to make these 4 rule changes. And I want to emphasize that these 4 rule changes really were in furtherance of what is already in the spirit and intent, and what is sometimes explicitly stated in both the Mls policies and the Code of Ethics. So these rule changes were really to further all of our existing objectives. So we agreed to make, as part of the settlement, these 4 rule changes. The first was the disclosure of commissions. There, the rules would be changed to no longer allow that the offer of compensation be restricted or not be displayed. It would have to actually affirmatively be displayed and provided to consumers before they made an offering on a listing. So it could no longer be held as a confidential field in the Mls, and realtors would have a duty to provide that information to their clients before an offer was made on the property. The second rule change was that there be a prohibition on the advertising of real estate services as free. Now that rule and that prohibition actually already exists, as many of you hopefully and probably know, because that's already in the Code of Ethics. But here the Department of Justice desired further clarity and that it be more explicitly stated. So we agreed to do that as part of the settlement. Third, we agreed to a rule that would prohibit the filtering of Mls listings based on the name of the listing agent or broker, as well as the offer of compensation. Now, again, you all know that you have agreed to abide by a very strict code of ethics, that you serve your clients' best interests at all times. And so you already have an existing obligation to deliver all of the listings that meet your client's parameters, regardless of the offer of compensation or who the listing agent or broker that would explicitly prohibit the delivery of listings to consumers based on these restrictions. And then last, we agreed to a change to lockbox access. And here it would allow, this rule change would have allowed any non-realtor, so any practicing licensed real estate licensee in the geographic region where the property is located, to have lockbox access. And here we envision that there would be reasonable parameters around that access. Now, you might be wondering, why am I going through these rule changes that have resulted in the withdrawal of a settlement? There is a reason, and I will go into that in just a minute, but I wanted to make sure that you understood these 4 key rule changes that NAR had agreed to make. So pursuant to the terms of our settlement agreement, NAR had to fulfill its obligations, which NAR did. We worked in good faith to adhere to the settlement terms and what we had agreed to. So those obligations on NAR's plate were things like notifying you all of the settlement, notifying our associations, our MLSs, our members. Also, we were obligated to provide the Department of Justice with a draft of the proposed rule changes to effectuate these 4 things. And we were obligated to provide that draft to the Department of Justice for their review and approval in the beginning of January, which we did. We provided them those drafts. The settlement required that those draft proposed rule changes be reviewed and approved by the Department of Justice before they could then be provided to our board of directors and our board of directors for its review and approval. So there was a 2-step approval process before these rule changes were to take place. We delivered those rule changes to the Department of Justice in early January. We never heard back. Very unusual. During the time period from January to July, we had a few conversations with the Department of Justice. They had approached NAR about language that existed in the settlement agreement concerning the reservation of rights. And basically what that reservation of rights says is that the Department of Justice has the ability to pursue investigations in the future. So the Department of Justice is not tying its hands from pursuing future investigations. We didn't fully understand what the proposed rule changes were, or I'm sorry, the proposed change to that particular clause in the agreement meant and what they were trying to achieve with it. So we tried to have those discussions with the Department of Justice to really no avail. When very suddenly they gave us an ultimatum and said that if we did not agree to their change to the reservation of rights language, which we had yet to really understand what they were trying to achieve with the amendments to the provision, they were going to withdraw the settlement the next day, which they did. We could not at that point agree to give up rights that we didn't even know what we were giving up in exchange for who knows what. So we couldn't make that call that quickly without a full set of information and facts. So the Department of Justice went forward and withdrew the settlement and voluntarily dismissed the case, which they have a right to do in federal court as the plaintiff. So they voluntarily dismissed the case. So what transpired after that? Well, very shortly after withdrawing the consent decree from the court and after voluntarily dismissing the case, the Department of Justice was very public in its statements that the reason behind their actions was because they did not want to have their hands tied to investigate NAR further. So they felt that that action was necessary in order to continue to investigate NAR. Beyond that, you might be thinking, well, why did they do this? And really, we can only point you to the Department of Justice because they are the only party that knows why they did this, why they went through this process where they, NAR negotiated and reached a settlement with them in good faith. That settlement was also approved by the head of the antitrust division at the time. and it was entered into court. And so this move in withdrawing the consent decree is unprecedented. It really is unprecedented that the Department of Justice would reach a settlement, submit it to the court, promote it as being in the public interest, and only to later withdraw it. So NAR took a somewhat an equal unprecedented action, which was to file a petition to quash. And that petition was just here recently filed on September 3rd. What does that petition to quash mean? Basically, it is NAR's effort and plea to the court to get the Department of Justice to have to live up to its end of the bargain. And what is the Department of Justice end of the bargain? Well, when we entered into the settlement agreement with the Department of Justice, we also received an agreement from the Department of Justice that in exchange for NAR's agreement to make these 4 rule changes, that they would then and thus close their investigations into both the participation role, which is, as you all know, that offer of compensation that you have to offer to other MLS participants by virtue of being a participant, and their investigation to the clear cooperation policy. And further, that we would no longer have any obligation to respond to the CIDs, which were the inquiries that the Department of Justice delivered to NAR. We would no longer have an obligation to respond to those CIDs. And CIDs are basically like a subpoena that requests documents and information from an entity. So that's what NAR got. We got an agreement from the Department of Justice to close its investigations and to no longer require NAR respond to those 2 civil investigative demands. In exchange for that, what did the Department of Justice get? They got NAR's agreement, among other things, to effectuate these 4 rule changes. NAR, as I said, we went through the process. We lived up to our end of the bargain. We did everything we were required to under the settlement agreement, only to have the Department of Justice, as I said, in an unprecedented move, withdraw from the agreement. So we filed this petition to quash to try to get enforcement of the settlement agreement and prevent the Department of Justice from reneging on this fully negotiated and approved settlement from November 2020. So NAR was really left with no choice here because of the Department of Justice's actions. And we want to prevent the Department of Justice from backing out of this agreement. And that is where we are with this matter at this point. So as I said, that petition was just filed here September 13th. So we're now going to work our way through that process, which we've been assigned a judge, and then it'll be up to the Department of Justice to respond to our petition. Now, the reason that I went through those 4 key rule changes is because I want to tell you kind of what's happening now, because as members, you probably heard for the past several months about these 4 proposed rule changes that were going to take place, and that members and associations and MLSs were preparing to effectuate and understand so that they could comply and carry out the terms of these rule changes. So what happens to these rules? We've gotten that question many times, and for a period here, we didn't know what was going to happen with those rules. But as you know, I'm sure full well, that NAR is always working to promote transparency and efficiency and work for buyers and sellers, as well as real estate professionals, to help support the dream of homeownership. And so whenever there's an opportunity, NAR always will be in a position to review our rules and make sure that our rules are up to date and consistent and serving consumers and real estate professionals well. So we decided that irrespective of the Department of Justice's actions here, we would take these rules and let members decide whether or not they should be moved forward. So as part of that process, we took these rule changes, these proposed rule changes, to the MLS Advisory Board for its review and for that initial review to decide should these rule changes move forward, irrespective of the Department of Justice's actions and irrespective of the fact that we no longer at this moment have a settlement that we're carrying out. And so that did happen here this month. The MLS Advisory Board took a look at these rule changes and our draft proposed changes to the existing rules and how we would carry out these rule changes. And they made a decision to carry forward to November for the MLS committee's consideration 2 of these rule changes. And those are the prohibition on the advertising of services as free and also the filtering of MLS listings rule. Now, that is not to say that the other 2 rules will not move forward either. Specifically the disclosure of commissions. We'll see where that one goes. But for sure in November, the MLS committee will be considering rule changes to effectuate the prohibition of advertising services as free and also the filtering of MLS listings as a listing agent or broker. I do want to briefly make one clarification about the prohibition on advertising services as free. And that is to say that the intent of that prohibition is to not prohibit any of those prospecting services that you all do to get new clients on board, such as providing free CMAs. It's really intended to prohibit the advertising of real estate transaction services as free to clients. So once you have that client relationship, so all that prospecting work that you do to provide and to generate new clients would not fall under this prohibition. It's not our intent that that activity be covered under this prohibition. So that's where we are. We're going to continue to fight in the courts through our petition to quash to get the DOJ back to the terms of the settlement, and to also I failed to mention that we also received a new CID, which was that subpoena I told you where the DOJ requests information and documents from the party. So shortly after they withdrew from the settlement, they did issue a new CID that looks very similar, almost identical to the ones that they agreed to close as part of the settlement. So the petition to quash will seek to get us back on track for the settlement, as well as set aside those CIDs that were received that the Department of Justice agreed NAR no longer had an obligation to respond to. And then we will look forward here to November to see what the MLS committee will do with those 2 proposed rule changes that will move forward from the advisory board onto the MLS committee for consideration and a potential vote by the NAR board of directors. So you'll want to be following that activity as we get into the annual conference. So this is one resource that I just want to highlight for you, and it kind of underscores what I said about these rule changes, which is that the rule changes that we agreed to really were things that were already in the spirit and intent, and in some places explicitly stated in the MLS policies and code of ethics. So this is a resource that you can find at nar.realtor, and it's specifically about your Article 3 ethical duty to cooperate. And that underscores the fact that right now, under the Code of Ethics, as realtors, you have a duty to cooperate. You have agreed to cooperate with other brokers, not just other realtors, not only brokers that belong to Realtor Association, but any broker when it's in your client's best interest. So we're always working in the best interest of our clients, and that extends an ethical duty to cooperate with other brokers, regardless of their membership status, when it is in your client's best interest. So check out that resource, share it with your agents, and I think you'll find it very helpful. So we also have a dedicated page on nar.realtor about the DOJ action and settlement. And I encourage you to go there and take a look at it and kind of highlight it, flag it for future reference, because that's where we're placing all of the updated information about the DOJ action. We're placing it here on this landing page, so you will be able to get the latest updates right here on the page. So at the top of the page right now, you're going to see an article about the petition to quash that was filed by NAR on September 13th. And then below that, you will see a video of yours truly from July, in which I very briefly announced the DOJ's action to withdraw the settlement. So you can reference those, and you can even go all the way back to November when President Oppler announced the settlement initially. But that is a great page to get information and the most up-to-date information, because we are updating it as soon as we have anything to share. So if there's nothing new, that means there's just there's nothing to share at this point. So flag that, bookmark it on your desktop. All right, so what else? Well, there's plenty else going on in the litigation area for NAR. In addition to the Department of Justice, there are class action law firms lining up who purport to represent a class of buyers and a class of sellers who have been harmed by the current MLS system. And so I will very briefly go into the details of these litigation just to give you the highlights in case you are not familiar with them. You should know about them. You don't need to be exactly experts in the cases, but there is a role for you all to play, which I will go into after I briefly describe what these lawsuits are about. So, and Sitzer, and they were filed just around the same time. And these two class action lawsuits purport to represent a class of plaintiffs. And this class of plaintiffs who are sellers of homes are represented by 11 class action law firms. So Murrell was filed first in Illinois, followed by Sitzer in Missouri. And it's very common in class action litigation to see copycat lawsuits, which is exactly what we saw here with Murrell and Sitzer. And so, as I said, both of these cases involve a class of home sellers, and the allegations in these complaints are virtually identical. And they allege specifically that it is the participation rule requiring listing brokers to make an offer of compensation to buyer brokers who bring that ready and willing able buyer to the table that has resulted in inflated commissions being paid to buyer brokers and a reduced level of service. So this class of plaintiffs allege that buyer brokers have a diminished role in the marketplace and that they don't serve the same purpose for one reason, because of the internet and because buyers can find their own properties on the internet and they can search for their properties on the internet. And so thus it must be that buyer brokers no longer have a role or their role is diminished. And if it wasn't for the participation rule requiring that participants make that offer of compensation to other participants in the MLS, buyer broker commissions would decline because of the diminished role that they play. The plaintiffs also cite to other countries around the world where they do not have an MLS system and commissions are lower. And therefore, the plaintiffs conclude that it must be that the participation rule is anti-competitive, thus causing these higher commissions. NAR strongly believes, of course, that these cases are wrong on the facts, they're wrong on the law, and that they're wrong on the economics. And so we are fighting very diligently to prove that to the court. In both of these cases, NAR filed a motion to dismiss. Those motions were denied, which only means that, and basically at that stage, the court takes the facts that are alleged in the complaint in the light most favorable to the plaintiff. And really all the court is saying by denying those motions to dismiss is that the case can proceed. So that's what's happening. The case is proceeding, and we're in the discovery phase, and we're heading into the class certification phase, which is another opportunity for NAR to win in these lawsuits, because in the class certification phase, the plaintiffs will have to prove and establish that a class should be certified. And in order to have a class certified, among other things, you have to show typicality among the class representatives, meaning that the plaintiffs can fairly represent every other home seller who potentially is in the class of plaintiffs that would have an opportunity to recover. As you all know, that is going to be very difficult to do because each real estate transaction is unique. And so it's very difficult for a couple of class representatives to represent every other home seller, every other home seller's transaction in the class. So this is an opportunity that if NAR is able to succeed and that a class is not certified, that these cases will become much less attractive to the class action attorneys that are leading the charge here, because what the class action attorneys are really looking for is that large class award. That means big bucks to them. And so if they don't have that kind of pot at the end of the rainbow, these cases will diminish in value to the plaintiffs. So that's where we are with these two cases. The third case that I want to point to very quickly is Leader, and that was filed after Sitzer and Merle. And here it is also a class action lawsuit, but instead of sellers, this class of plaintiffs purports to represent buyers who allege very similarly that they have been damaged because of the inflated cost of a home that is a result of the commissions that is being paid to the brokers. The complaint alleges that the buyers are indirectly paying for the services through the purchase of the home. So I'm telling you something that you already know. The seller pays the listing broker the commission, who then splits that commission in some manner and pays an offer of compensation to the listing or the buyer's representative. And so the plaintiffs, the buyers are alleging that they are indirectly paying that inflated because of the inflated commissions. We have filed a motion to dismiss in this case as well, and feel very strongly as to our positions, because there is a very well-established concept in antitrust law which prevents indirect purchasers like the buyers, and here the plaintiffs have even admitted as much, that they are indirect purchasers of the services because they are not directly paying for the commission. And federal law only allows direct purchasers to bring a claim under federal antitrust law. So we've made that argument in our motion to dismiss, which is currently pending before the court. And we are hoping that a decision on that motion to dismiss will be made soon. So these are the cases that, these are among the cases that NAR is fighting, and I've chosen only to highlight these for you today. There's a few more, but these are the cases that we're fighting on behalf of the industry and of the marketplace, and in support and commitment to the MLS and its ideals and what it strives to do, which is provide transparency and efficiency to the marketplace, and which is really unique for the real estate marketplace around the world. It's really the envy of other countries that we have this MLS system that works so well for the benefit of buyers and sellers. So NAR, as I've said here, is fighting in the courts to make sure that we get the right decisions on the law. But we also need the support of you all as members, and we need you to help serve us and further these cases in the court of public opinion. And so that's where you all come in. And we ask that you start talking about your value and start demonstrating that value to the public, to consumers, to your clients, so that it doesn't go unnoticed, so that they understand the services that you bring as the listing agent and as a buyer's representative, all of the amazing and wonderful things that you do to service your clients and make the dream of home ownership and the home buying and selling process so efficient and possible and attainable. So talk to your consumers, your clients, and tell them your story. Talk about the value that you bring to home ownership, that you are out there advocating on the advocacy front to make sure that private property rights are maintained and that you are serving your communities, which I know that you all are doing as realtors. There's so many amazing stories of how realtors serve their community, and you really are leaders in your community. Make sure the consumers know that. Talk about the MLS system. Help consumers understand how the MLS system works. The value that it brings, that it creates these competitive and efficient marketplaces for the benefit of home buyers and sellers, as well as you all as small businesses. And then be sure the consumers know that you are the local expert and that you play a critical role, again, in making that whole real estate transaction possible. And further, that, as I said, that these lawsuits are wrong in the court of in the courts, on the law and the economics. And so this is a story that we want you all to be telling and continue to tell to consumers, and shout it loud. You can do it in so many different ways when you're meeting with prospective clients, when you're servicing clients, in your local newspapers. You can do op-eds. I mean, wherever you have an opportunity, the public needs to understand the value that realtors play and the role that you play in the home buying and selling process. And without you, really what an inefficient marketplace it would look like. And especially also the MLS system. We, I think, sometimes take for granted that the public understands all this because we're so immersed in the MLS and real estate buying and selling that we don't understand that consumers might not understand really how the MLS system works in the way that it works for their benefit. So to help you have these conversations, NAR has created a number of assets that will help you have these conversations. So here I'm showing you the MLS system in action. It shows you what does the world look like with MLS and what would the world look like without the MLS? And we don't want that. So help them understand what the MLS brings to the world. Share this with your clients and your prospective clients when you're having those listing presentations and meeting with prospective buyers. This is also an infographic that will show how real estate agents can bring value to the transaction and how consumers can maximize that value. What can they look to their real estate agent to do for them? What are the services that they're going to provide? How are from using a realtor? And what are they paying for in that commission that they are paying their agent? And then last, the economics of buying a home. Another great piece for you to share with consumers about how you all, again, make that home buying process, especially for first-time home buyers, minority home buyers, possible. You can find all of these infographics here on this same link. It's general member message points on the antitrust lawsuits, which will go into even more detail about telling your story here. And then you'll be able to link to each of these at the bottom. So please go check them out, use them, and look back for more resources. All right, so now with that, I'm going to turn to some hot topics to help you all kind of mitigate your risk and understand some of these issues that are on the forefront of legal challenges facing real estate professionals today. So first up, fair housing. So hopefully you all have heard about NAR's Plan Act, which NAR announced just recently that demonstrates NAR's intent to raise the bar for fair housing and to ensure that realtors do everything possible to protect housing rights in America. Again, as real estate professionals, you have a legal obligation to uphold and comply with the Fair Housing Act, whether that's the Federal Fair Housing Act or your state law. And then through the Code of Ethics, you also have pledged to uphold the ideals of the fair housing laws in servicing consumers and providing equal access to housing for all. So what does ACT stand for? It stands for accountability, culture change, and training. And every member has a role in helping further this fair housing commitment. This shows some statistics from the 2020 NAR profile of home buyers and sellers. And these hands represent what do home buyers and sellers look like? As we can see, 83% of home buyers and sellers look very similar. And then here we're seeing percentages of minority home ownership, which are extremely small in comparison to this one hand. And we need to do something to help support minority home ownership, to make sure that we are providing housing and equal access for all individuals who want to own a home. That's really the basis of what you do, is helping people find that home. And so equal representation is a very important part of that. African-American home ownership rate fell to an all-time low in the second quarter of 2019, which astonishingly is lower than when the fair housing was even enacted. I mean, that is just astonishing and underscores why NAR committed to this new plan of ACT and why we're talking about this today, because something is not going right. And so we need to do our part to make sure that fair housing is something that we're all upholding and thinking about when we're servicing clients on a daily basis. You all might have heard about an investigation that was conducted on Long Island not too long ago, where testers went out into the marketplace. 93 real estate agents were tested as part of that Long Island investigation. And you can read more about it through this link. Hopefully my slides will be shared, but you can read more about the Long Island investigation here. So as a result of that Newsday investigation, 93 real estate agents were tested. And what did they find? That investigation revealed that minority testers received different listings in different communities. What does that sound like? Steering. African-American testers received 50% fewer listings to view compared to the white-paired tester. As you all know, steering is a prohibited practice under the Fair Housing Act, yet these testers found that the minority testers were receiving fewer listings and in different places than the white testers. What else did this investigation reveal? 8% of the Long Island testers revealed that there was discrimination in the form of prerequisites, another kind of red flag for fair housing. How mortgage pre-approval works, the buyer brokerage agreement that was entered into with the buyer, and the ID for showing homes. So what are you requiring? What barriers are you putting up for home buyers and sellers to access the housing market? We need to be thinking about that because, again, fair housing and equal representation for all of somebody's race, ethnicity, religion, disability, familial status, and so on. It really needs to be regardless of any of those factors. And then finally, 24% of Long Island tests showed evidence of steering, which we just talked about. So this investigation was really kind of a big news story because it highlighted how much room we have still to go. That the Fair Housing Act was enacted a long time ago, but we're still seeing that there are fair housing violations occurring. And so more training and better attention needs to be paid by real estate agents to make sure that they are servicing clients and not violating the federal fair housing law. So what does the federal fair housing law prohibit? It prohibits, I'm sure I'm telling you something that you already know, but it prohibits discrimination in all aspects related to housing, whether that's renting, buying, getting a mortgage, seeking housing assistance, or any other housing related activity. And specifically, it prohibits discrimination based on certain protected characteristics, which I mentioned a few of them. So what are they? They're race, color, national origin, religion, sex, and familial status. And just recently, there was a memo issued by HUD clarifying and coming out to say definitively that they will interpret this prohibited discrimination based on sex to include sexual orientation and gender identification, which was really big. Sorry, I forgot to click the last one, disability. So those are the 7 prohibited bases upon which you cannot decide whether or not or how you service clients. It needs to be on an equal basis without regard for any of these particular characteristics. So here's the HUD memo that I just mentioned that makes clear that HUD will enforce sex as a protected class to mean that discrimination is prohibited based on sexual orientation and gender identity. But again, as realtors, you have agreed to abide by a stricter code of ethics. So that means that you are already obligated under the code of ethics, Article 10, which has included sexual orientation and gender identity to the list of prohibited bases upon which you can discriminate against someone in the provision of your services. So we're already there. You're already used to that. So prohibited conduct, what does that look like? I've covered some of this, so I'm just going to briefly go over this, but it means a refusal to rent or sell, steering, as we've talked about, block busting, and now I want to touch very quickly on 2 specific areas of fair housing that are kind of emerging areas of potential risk to real estate professionals and things that the fair housing conversation is focusing on. The first one is school information. I'm sure you all encounter this, maybe even on a daily basis, when clients are asking, well, is that property in a good school district? What is a school? What is a good school district? That is very subjective. What might be important to me may not be important to the next person. Maybe I'm not so focused on test scores, but I want to know what's the student to teacher ratio, or what's the size of the school, or how many AP advanced placement courses does it offer? What are the extracurricular activities that are available? What is a good school, as I said, is very personal, and it's an individual thing. What I deem to be a good school may not be what someone else deems to be a good school. A lot of the websites that rate schools, you really need to be careful of those, because a lot of times they will rate schools based on test scores, which correlate with the socioeconomic status of a community, which means that if people are sent to what is perceived to be a good school district, that could be pushing people into one community as opposed to another based on that socioeconomic, that racial makeup of the community. So how do you talk about schools with your clients? Well, here are some best practices. First, avoid offering a subjective opinion. Avoid offering your personal opinion about what is a good school. Instead, what you can do is direct parties to third-party sources of information, such as school administrators. Point them to the actual school district to have a conversation. Maybe point them and suggest that they speak to a parent who has a child in the school. But avoid giving your own subjective information, and encourage them to seek third-party sources of information. Of course, one of those third-party sources of information could be schools. So make sure when you refer clients to a website that rates schools that you're confident in how they're determining the value or the ranking of that school. So make sure you understand their methodology, and then it won't further a way of steering clients to one community or another, away from another. The other fair housing issue that is definitely being talked about a lot these days is buyer love letters. And before well, I'm sure you all know what a buyer love letter is, but it's where consumers, clients want that home, especially in this competitive marketplace where, we've seen multiple offers on properties just as a matter of course. That is the rule, not the exception. And your buyer wants to win that property. They're desperate to win that property. Maybe they've lost out on other properties before that. So this is a buyer's attempt to distinguish themselves and set themselves apart from the competition to get the house. These letters often, of course, reveal personal information, whether it's religion, familial status, race, all of those kinds of things can come out in a love letter very innocently, but they can then serve as a basis for the seller to make a decision based on the information that is included in the letter. And it can trigger, as I've said here, implicit bias, where the seller prefers one buyer over the other based on a feeling. Now, just earlier this year, Oregon passed a law banning buyer love letters, and that law is set to take effect in January 2022, which is the first and only law of its kind that I'm aware of, but it specifically prohibits real estate professionals in Oregon from delivering or taking any part in buyer love letters. So what are some best practices? Because you're probably thinking, well, my buyer wants to send it. What am I going to do? How am I going to stop them? If your buyer is going to do it, you need to educate your clients. You need to educate your clients about the risks. To the extent possible, encourage and urge them to not include in that letter any information that reveals any of those prohibited bases, such as their race or religion, familial status, discrimination, national origin. Educate clients about the risk of using them, and if they're insistent upon using them anyway, you really should not take any part in relaying or reading or receiving that letter. Remove yourself from the situation, because you don't want to be involved in a scenario where you are transporting and transmitting that letter to the seller, where they may potentially make a decision that's in violation of the Fair Housing Act. And then make sure you document your decision-making process. NAR has so many fair housing resources, so I'm going to point you to our fair housing page on nar.realtor. I also encourage you to check out our bias override video, which is a place where you can learn about implicit biases. We all have them. They're, just natural from how we grow up, our experiences. But this video and this topic in general will encourage you and challenge you to think about some of these implicit biases. You may not even know that you have, but they'll bring them to your conscious, and you can understand how to overcome those barriers to really servicing consumers and clients in a way that furthers fair housing and doesn't hinder it. If you haven't already, check out Fair Haven today. It's an interactive training resource that NAR rolled out this year, and it's free to all of you. It's an hour long, and you can, it's an interactive kind of simulated training course, and it sets you up as a real estate professional, and you're forced to make different decisions. You're confronted with fair housing issues, and you have to decide as the person in this training, what do you do? What's the next action you take? So it's an hour long, it's really quick, but you might learn something. And then here are some publications that you can learn more about. I would highlight this at the end, but I'll just highlight this now. This is the Real Estate Brokerage Essentials book. If you haven't, if you're not familiar with it, check it out at the Realtor store. It covers so many different issues, things that I've talked about here, as well as many others that confront brokerages in their day-to-day business. And here's another list of resources that hopefully you'll have access to when you get my slides. All right, copyright and listing photos. I know we only have about 14 minutes, and I want to leave quickly through the rest of my material to allow for some time, but I will hit the highlights. What is a copyright? It's an original work of authorship fixed in a tangible form of expression. So that means that if I create something and the bar is very low for what is original, what is creative, that copyright would attach to it, the bar is very low. As the author, my ownership in that creation, that material is created as soon as the work is created. So if I draw a picture, I have a copyright in that picture. It's mine, I created it. You can also get the copyright ownership rights through a work made for hire agreement. And that's where you have hired somebody, a third party, to do something. And you have an agreement under which the person is agreeing that anything that they create, ownership automatically transfers to you through that, by virtue of that agreement. Or you can obtain a copyright through a third party assignment agreement, where the third party is assigning you rights to that copyrighted work. And that can look in a host of different ways. It can be, there can be limits to it. It can be expansive. So you need to really understand, when you have a third party agreement that's transferring copyright to you, what those rights are and what you can do with the copyrighted work. So why does this matter to you all? Listing photos. It is a huge issue in the real estate industry. And you need to think about copyright when you are having listing photos taken by a third party. If you own the photos by virtue of an agreement, or you took them yourself, great. You can use the photos however you want. You can transfer rights in the photos however you want. Or if you're hiring a third party to take those listing photos for you, and you have a license agreement, hopefully you have a license agreement, you can only use the photos in compliance with the terms of that license. So you need to really understand what the license says. Any misunderstanding or misuse of the copyrighted work, the listing photos, in a way that circumvents or is contrary to the license that was created and given to you, that places you at risk for a copyright lawsuit. So how do you mitigate this risk? First, review your photo agreements. Make sure you understand what the rights are that you've been given, and that you are using the photos in the proper way. So audit your photos. Make sure your use of the photos is in compliance and permissible under the relevant license that you've been given. Make sure when you're entering into these agreements at the outset that you are considering your future use of the photos. So make sure that that agreement aligns with how you plan to use the photos in the future, or how you plan to transfer right to use those photos to a third party like the MLS. Also keep records, because if somebody comes to you and says, hey, that's my photo, you don't have permission to use it, You want to be able to easily confirm that you are using it properly and prove your rights if you are challenged. If you don't have photography agreements for these listing photos, you need them. And so NAR has put together some sample photography agreements that you can take and use and adapt for your own purposes. So there's a work made for hire agreement, which if you'll recall, that's where you're hiring a third party who is agreeing to transfer complete ownership of that work to you. That's the best. That's sort of like the gold standard. You're going to be the owner, meaning you can do anything you want with these photos. There's an assignment agreement where they're going to assign rights into the photos for you, or an exclusive license agreement. So you can check all of those out on nar.realtor. They're there for your use. Please feel free to take them and use them. Best practices for music licensing. So you might use licensing music at an open house or at an event that you hold for first-time home buyers or something of that sort. And so you need to make sure that you have the rights to the music that you're using. You can't simply turn on your Pandora or your Spotify and play it at an open house or one of these seminars that you might host, because you need to confirm that the license in that service allows for the commercial use. And you will likely need to purchase a different license in order to use Spotify, Pandora, those types of services for commercial use. Now, on top of that, if you plan to capture music in a video, you also need what's known as a synchronization license. So you need one performing rights license, so that's a live performance at the open house. But if you plan to record the open house, or you want to record the seminar where you're playing this music and the music appears in that video, a unique license called a synchronization license so that you can incorporate that music into a video. And then a master recording license will cover a particular sound recording into a video. And so you want to keep that in mind whenever you're using music, either live or in a video, to make sure that you have the proper rights and licenses to use that music the way that you are. So what do you do if you receive a cease and desist letter, meaning somebody confronts you and says, hey, that's my copyrighted work, that's my photo, that's my music? What do? First, let your insurance carrier know. You need to promptly let your insurance carrier know of any potential legal action or demand brought against you. Consult with your attorney and then evaluate the merits of the claim. Is the copyrighted work that they're asserting ownership over, is it adequately described? Does it include the copyright registration details, which is required in order to obtain damages for a copyright violation? And do you have a license? So that goes back to my point about keeping records. Be able to pull that agreement out and say, hey, no, I have a right. This shows that I can use this music, this photo in the way that I have. And so if you need to, you can request additional information to understand what the alleged copyright owner is asserting that you have infringed. And then last, very quickly, so I can leave a few minutes, I just want to briefly talk about ADA website accessibility. So you all are probably familiar with ADA accessibility requirements from a physical standpoint. For many years, decade at least, the conversation has really turned to ADA website accessibility and whether websites have to be accessible. We have yet to receive clarity on this. The DOJ, I mean, this dates back to the beginning of my time at NAR. It was one of the first issues I was tasked with, which was 11 years ago. The DOJ had issued a proposed rule on website accessibility and the application of the ADA to websites. That proposed rule has never gone anywhere, and the DOJ has never taken any action to provide clarity, which has resulted in a lot of litigation and an increasing amount of litigation where plaintiffs are alleging that websites are not accessible in violation of the ADA, yet we don't have anything concrete. ADA was enacted at a time when the internet was around, but it wasn't really used, obviously, to the extent that it is today. What does the Department of Justice say? Well, they say all websites are accessible. What does the court say? It's a little bit of a mixed bag, but overwhelmingly they do tend to hold that the ADA does apply to websites. But we did just recently have a positive decision in the 11th Circuit in a case called Gill versus Winn-Dixie, where the court held that the ADA did not require accessibility of websites. So that was a very positive development in the 11th Circuit, but we still have the rest of the country, and we still have the DOJ saying that websites are accessible, and we still have plaintiffs filing lawsuits for violations of ADA website accessibility. So how can you mitigate your risk here? Create and maintain an accessible website, work with an outside vendor who understands and knows how to build accessible websites. Visit with your website vendor right now after this program and have the conversation with them about the accessibility of your website and what needs to be done to upgrade your website to enhance its accessibility. Also, in your website terms of use, it's a good idea to have a consent to arbitration to require that anyone that wants to assert a violation cannot go through litigation, but will have to arbitrate their claim with you regarding website accessibility. Also include an accessibility policy on your website. NAR has a sample one, which is hopefully linked in my resources that you can take and use. That is definitely not a surefire thing to prevent you from potential legal action, but it does tell users that, hey, this is an issue I care about, I'm aware of, and here's how you can contact someone if you're having trouble using my website. Make sure you address this in your vendor contracts, and be careful when you are linking to third-party sources that information is also accessible, because we don't have a rule, so we don't know the limits of the requirements for you as a website host in terms of accessible content. So make sure any content, yours or third party, is accessible. And one more thing I want to highlight where you can find more information, more links, is this Broker Hot Topics document that we update twice yearly. And if you go to nar.realtor and you even just search hot topics and broker hot topics and risk reduction, you will find this and you will find all of these topics and more, and all of our resources that are available to you to learn more, to help you all mitigate your risk and prevent the next lawsuit from being served on you. And then finally, a reminder about your code of ethics training requirement that is must be completed by December 31st. I've left 3 minutes for questions. Kelly, what do you have that needs attention?
First, let me just say great information, and you really ran through it. And I got to tell you, every bit of it was incredibly interesting and obviously fascinating, what all the work you're doing, which is really behind the scenes as far as most of the members go. So thank you so much for what you are doing. And we're going to get into some Q&A. One is that came up is, okay, so you walk into a house, the seller has the music on the TV, one of the music channels, because they want people to come in and tour the house, you know, with each of the agents and appointments. Violation or not?
Yeah, I mean, so that's a situation where there's probably low risk. But as I said, these licenses for just a sort of run-of-the-mill Pandora or Spotify is probably does not include commercial use. So you really do need to have your own account for commercial use that you can use whenever, wherever you want. So you don't have any risk.
So should we tell the seller to turn the TV off?
Turn it off and you're in a takeover.
All right, well, Craig wants to know this. How does the cooperation policy on the Code of Ethics apply, if at all, to firms who have a policy to pay a lower commission split to non-MLS members versus MLS members?
Okay, okay, so we're talking about Article 3, a duty to cooperate, and how does it apply to, say it again?
Okay, agents who are members of MLS with the firm and realtors, or let's just say licensees, okay, who are not with a firm and part of an MLS.
And how that applies
to the policy, right? And they have a policy that states that the firm is going to pay a lower commission to those who are non-MLS as opposed to those who are MLS members.
So the offer of compensation is a requirement that has to be offered to participants in the MLS. If the broker is not a participant in the MLS, then you can make whatever offer you want, as long as you're making that unilaterally and independently and not part of any collective action. But you always have to be conscious of your Article 1 duties, which is to act in the best interest of your client. So when you are making those offers of compensation or commission to a non-realtor or non-participant of the MLS, make sure that that is working in your client's best interest.
Okay. Second is, and Kristen wants to know, this is good because I use RPR a lot. RPR offers school reports. Do you suggest we use these?
Yes, I do. And I have to admit that I don't know exactly what their school reports are. So I probably shouldn't use them because I'm not confident in the methodology. So I'm not familiar with it. But, it's one source of information. But as I said, avoid giving your own information about schools. Just kind of avoid having that conversation with your clients. Point them to third-party resources. So it could be a website that offers school ratings, or third parties like parents and administrators.
And really, the Newsday article really talks about why is it the realtors are, should consider themselves true experts on schools, when in fact, exactly what you're saying, there's just so many parameters and what's important to different people. So is there any talk about agents eliminating their headshots to avoid implicit bias to pick an agent based on their looks or race?
I haven't heard that. No, but that certainly could serve as an implicit bias for how buyers and sellers are choosing their agents. But at that point, we're not talking about fair housing, right? We're just talking about the consumer's preference, which could be because I like someone who has red hair, or I like someone who has brown hair, or I want to work with a man or a woman or whatever it might be. Really, we want to be talking about implicit bias with real estate professionals and make sure that those implicit biases are not impacting how they're servicing prospective clients, how they are offering their services or willingness to work with a client, or servicing a client.
And one of the concerns I have, and by the way, I serve on NAR's risk management and have been appointed vice chair, is this: when you've got homes where there are cameras that are involved, granted it's illegal to listen to anything that they're talking about, but they can see who's coming in the home.
Mm-hmm.
And then that sometimes, as far as for us, does that get into, again, a bias type situation because they're looking to see who's coming in, who they like, maybe who they don't like, or just whatever the case may be, instead of just merit-based offers?
Certainly. If I'm a buyer and I can see who the person that came in for the third showing and I get an offer from them, and I then so like the scenario would be where the person comes in, they give an offer on the property, but there's another competing offer. And now I've seen the offer, I've seen the people who placed the first offer because I was looking at them through my camera. But the second offer might be stronger. It might have better terms. It might be closing when I want to. They might not have a financing contingency. And if you go with the first buyer because you don't like what the other buyer looks like, then you have a problem. The seller potentially has a fair housing issue.
And that's exactly why when I'm giving offers, this is personal commentary. I basically do like a spreadsheet. If there's more than one offer, there are no names involved. There's no, it's just strictly terms. They don't know who came in first or whatever the case may be. Here it is, pick one that you like better.
That's a really good point, because names are another way that people can make, even unconsciously, decisions about who to select. So buyers, sellers need to be focused on the objective criteria about the offer.
And then we've got one last one that's here. And David wants to know if NAR is developing a pamphlet to hand out to buyers about why love letters are not a good idea, or why we don't want love letters.
No, we don't. We have a lot of resources for you all, but not so much for consumers. But I encourage you to look at our resources. We just did a recent Wendula Law, which I hope you're familiar with that series, but they're really quick, like 5-minute, probably less. We're trying to stay around 3 minutes. They're issued every month on a very current and pressing topic. And we just did one on buyer love letters. So avail yourself of our resources to then have those conversations with your sellers and buyers.
And I'm sorry, one more. Are clients subject to fair housing violations and subsequent penalties?
They are. They can also be implicated in fair housing lawsuits.
Very good. Leslie, thank you so much. Leslie, you've been terrific. I'm always fascinated, somewhat of a frustrated attorney wannabe myself. So again, you're welcome to come back as many times as you want. NCR certainly appreciates all your effort today and your time today.
Yeah,
so I'd
absolutely.
like to and I just want to thank all the members of NCR who participated in this today. Again, a link will be sent to you, not only of as far as this recorded session, but all the links, slides, everything that Leslie's put in as well. So you'll be fully informed. And please take advantage of all the resources that the National Association of Realtors offers, because again, there's a tremendous library and resource for all of us, and it's part of your dues. So again, Leslie, thank you very much. Thank you all the realtors. Don't forget to do something nice for yourselves, and thank you for what you do for your clients and servicing the communities. Take care.
Thank you. Bye.